Under that first charter, there was a president of the colony and 4 assistants, 1 from each of the 4 towns. They functioned both as the general officers of the colonial government and as its judges. Each of the towns had its own municipal court to deal with local matters. But what was referred to back then as the General Court of Trials heard the more complicated cases, including serious crimes, serious civil cases, and the appeals from the local courts. In 1663, the remarkable Reverend Roger Williams received another charter, this time from King Charles II. Now, King Charles I, you might remember, was beheaded. I always joke that he was 5'8" when he took the throne and only 4'6" when he left it. But his son Charles II reestablished the monarchy in England and granted a second charter to Roger Williams in 1663. Under that revision, there was a governor, a deputy governor, and 10 assistants, all of whom were elected. And they served both as members of the General Assembly and judges on the General Court of Trials. In 1729, the General Assembly finally decided the state into 3 counties, Newport, Providence, and Kings, which later became Kent County. Each county had its own court, and the appeals, though, were still heard by the General Assembly. As the colony grew, the appeals court began to move from county to county to hear those cases. And finally, in 1790, the General Assembly passed a law that prohibited those who held elective office from serving as judges at the same time. Now, it's amazing to most scholars that Rhode Island had no state constitution until 1842. Although we existed since 1636, we were one of the first 13 states, we were the only one that didn't adopt a state constitution. And this is so because the charters of 1647 and 1663 were remarkable in their efficiency and because of the rights that they granted to the citizens of this state. And so, even after the United States became an independent country, and Rhode Island became a member of that country by ratifying the U.S. Constitution, finally, there still was no state constitution. Finally, in 1842, a constitution was adopted for this state. That document divided the functions of state government into the now familiar executive, legislative, and judicial branches. And it was not until that time that the General Assembly finally gave up its right to review, revise, or reverse any judicial opinion or decision. In 1856, the Rhode Island Supreme Court issued a landmark decision in the case of Taylor versus Place. In that case, the Supreme Court declared that it possessed all the judicial power in the state and that it would share it with no other branch of government. And from that decision forward, which really marks, I said about 150 years ago, the modern formation of our court, the General Assembly lost any vestige of authority to review, to revise, or overturn any judicial decision. Even at that time, the Supreme Court was different than it is today. In the 1840s, the courts consisted of 7 justices, not the 5 we have today, who split their work between the trial courts and appellate panels. It was not until 1905 that the Supreme Court became exclusively an appellate court and assumed its now familiar mantle, hearing appeals from cases that were tried elsewhere before only 5 justices. Although the Supreme Court is the only court that is established in the Constitution, we now have a variety of state courts. Those include the District Court, which sprung into existence by act of the General Assembly in 1886, the Superior Court, which hears the more serious crimes and civil matters, and which was created by the General Assembly in 1905, and the Juvenile Court, which was created in 1944 and then was later merged into the Family Court, which itself came into existence in 1960. But it's interesting to me that, except for the very earliest colonial times, there was no authorization for any court at the city or town level at any time in our history. It was not until 1964 that the General Assembly authorized a municipality to establish a local court. You may be surprised to learn that the first municipal court authorized by the General Assembly was for the town of Johnston. As I prepared my remarks for today, I did some research to try to determine who was the first judge of the Johnston Municipal Court, and the first name that I came across was that of Fred DeCesaris, who later went on to a distinguished career as a United States magistrate. The reluctance of the state government to create or allow the creation of municipal courts may have been a concern of state government that if allowed to establish municipal courts, the cities and towns would see them as strictly as a money-making opportunity, and that they would be unwilling to provide the necessary resources to those courts, or alternatively would provide them with meager facilities that would undermine the dignity and integrity of the judicial process. That obviously has not occurred in the town of Johnston. This town's commitment to local justice at the local level is obvious, and another chapter of that commitment begins today with the dedication of these impressive new facilities. I was interested when U.S. Attorney Nerona was speaking. He mentioned that the public has to have respect for the law, and that is absolutely true. But the law also has to have respect for the public. And by providing a facility to administer local disputes, a facility this dignified and this beautiful, it's obvious that this town does have respect for the public. I would be remiss if I failed to acknowledge the respect in which the judges of this town, the town of Johnston, are held. The chief judge, as Chief Magistrate Guglietta said of the town court, is Bill Dimitri. Bill has had a distinguished career in the law for many years. And many of you, I am sure, will remember, as I remember, Bill's late father, a former assistant U.S. attorney, candidate for Attorney General, and a longtime Superior Court judge. William Dimitri, the senior, was widely seen as a role model for those who followed him into the judiciary, and we miss him greatly. Judge Dimitri is assisted ably here by Judge Michael DiChiaro, a local attorney who has, through his own hard work and dedication, has built up a strong reputation in the legal community in our state. And finally, Paul DeMeo, who serves as your probate judge, has long been recognized as one of Rhode Island's most competent trial lawyers. I became a lawyer 36 years ago. And I can remember when I was a very young lawyer that Paul DeMeo was already a well-established practitioner, and I can recall personally watching him operate in the courtroom as I tried to determine how a trial lawyer ought to conduct himself and to conduct a trial. Professionally, Paul is also well known for his generous spirit in assisting young lawyers with advice and counsel. Sometimes Paul will give the advice whether you ask for it or not. In conclusion, I would like to again express my gratitude at being asked to participate, and it's always a pleasure to be asked to come to this great town. I offer my congratulations and best wishes to the town as it continues to provide consistent, high-quality, and effective local justice in these impressive new quarters. Thank you very much again, and congratulations to everybody.
Thank you very much. Thank you.